to reinvent the wheel. The interplay between 23 and 54 and how cesses fit or don't fit has been fully discussed. There are one or two cases which I'll have to deal with.
मेरी किताब खत्म होने जा रही है.
Section we need to show. So, my lord, and I say so candidly, in no case has there been, I mean, it may have been submitted to the court, but in no case will your lordship find a full discussion of 50. 23 and 54 have been discussed, and they do cast a shadow on 50. And there is a connection, which your lordship will see when I come. But in no case, this is the first time your lordship, and I am inviting your lordships to focus on 50 and interpret 50. But that discussion your lordship will not find. But after the trilogy of cases, there have been one or two others which I need to explain. One is that Chamanmal, and the other is the Western Coalfield Judgment, which analyzes all this and deals with it. I want to argue my case without citing either India Cements or Kesara. None of your lordships hearing, but I do propose to deal with India Cements after I finish first principles analysis. Now, I had finished showing almost all the provisions, just one or two.
Even if we come to the conclusion that in paragraph 34, there is an obvious error. We are a bench of 9, so anyway, we have to.
Neither way, Malad, it turns whether there is an error, whether there is not.
We have to look at it as a matter of
first principles, Malad. And I start by saying the only real assistance your lordship.
Unless we, of course, come to the conclusion that India Cement, which is what they will argue, have been arguing, that India Cement, as interpreted in Kesuram, does reflect the correct position of law.
Malad,
but then to decide that again, we have to decide it
again. Exactly, I have to criticize Kesuram's reasoning. If your lordship say no, I'm wrong in Kesuram and our submissions are wrong, Kesuram is right, that's the end of the matter, right. Or vice versa. So, but this whether Kesuram should have done this to India Cement or done that to India Cement, frankly, I don't think it's a very useful way of addressing the problem. And I start by saying, in none of these cases will your lordship find a rigorous analysis of two propositions. What really is the meaning of 50? And the different mantras, if I may borrow the Chief Justice's phrase.
Yes.
And the second, your lordship will not find in any of the cases is a rigorous analysis of 49 and 50. The special excluding the general, is it a carve out? Is it not a carve out? Everybody has said, okay, 15 on there, 49 is there. But can 49 operate on minerals in respect of 50? And the third, Malad, which needs a little clarification, the Raliaram principle, measure, was, Malad, for the first time, if one may say so, contained and clarified, not in Bombay Tires, in RR Engineering. Yes. Where your lordship said, yes, but you have to remember it is only a measure, don't make it a tax. And excessive levy starts then affecting not just the measure, but it starts affecting the tax itself. That's the first time your lordship administered that caution. Bombay Tires brought it back. And there are two recent cases where Acer, your lordship struck down. saying you can't include a non-dutiable item in a measure, and how that will play out in our case. So, but these are the three broad areas which your Lordship will have to consider, and none of these your Lordship will find has been analyzed. I start by saying in the judgment in our favor, India Cement, or in Keswara, the judgment against us. So really, it's for your Lordships to want to consider all these aspects and come to a conclusion one way or the other. I had almost finished there. One or two new provisions. One at section 70, which only show now the overriding powers. They added now section 17, which applies to all areas which vest in the government of a state or any other person, and give the central government the power to undertake reconnaissance, prospecting, and mining operations, and then they have to pay something. Details are not necessary, Manoj.
Yes.
And my lord, since your lordships have mentioned this, I must point out, and I don't need to read the section, section 18, conservation and systematic development of minerals. Now there is an express provision. Something, my lord, which is relevant to the entry 54 versus entry 23 discussion is section 20 capital A. Again, a newly added provision. This was added in 2015. Which says, notwithstanding anything contained, central government may issue such directions to the state as may be required for the conservation of mineral resources or any policy matter in the national interest and for scientific sustainable development, etc. Now, my lord, 21 has one addition. Your lordship saw 21 of the act as originally brought in. Please see 21 now. It says, whoever contravenes the provisions of subsection 1 or 1A of 4 shall be punishable with an imprisonment which may extend to 5 years. Your lordship saw section 4(1)A at page 925, where transporting. So if you even move it without paying royalty, it is now an expressly. And then we have 25. Say 24 is the power of inspection, etc., which is there earlier also. And then we have 25. Continues. Any rent, royalty, fee, tax, fee, or other sum due to the government under this act or the rules made thereunder under terms and conditions of any mineral concession beyond the certificate of the officer as may be specified by the state government. In this behalf, by general special order, be recovered in the same way as land revenue. Well, these are all statutory now, all statutory dues and liable to recovery in this fashion. And again, my lord, section 31 has the power of central government now has been given a power to relax any of the rules in the interest of mineral development. So, well, that's how the law is. It's spread wider. Yes, one last thing which remained, but I need to show your lordship the auction rules, one or two provisions, to show how now the state, how the mineral rights are transferred. Because that will be another aspect of the discussion on tax on mineral rights. Marat, volume 4, page 2176. Madam. Your Lordship will find the Mineral Auction Rules 2015.
Page 2.
2176.
Four.
Four. Just one or two rules, Amalan, what your Lordship needs to see, because the details are not necessary. Rule 8. Rule 8. Bidding parameters. State government shall specify in the tender document the minimum percentage of the value of mineral dispatched. Please mark that. Have some bearing on it. Which shall be known as the reserve price. The value of the mineral dispatch shall be an amount equal to the product of the mineral dispatch in a month, the sale price, grade-wise by the Indian Bureau of Mines. And the bidder shall quote, as per the bidding parameter for the purpose of payment to the state government, a percentage of the value of the mineral dispatched equal to or above the reserve price. And the successful bidder shall pay to the state government an amount equal to the percentage so quoted and the value of mineral dispatch. This is how mineral rights are now created.
The expression mineral development in entry 50 of list 2, can it not be related to only section 18 of the 1957 Act?
My submission is going to be that these are not terms of art. Conservation of minerals is an integral part of mineral development. So if you waste them, how are you going to develop them? So the question is where is the emphasis? Earlier, we believed only in regulating, let people do what they did when it was considered a private resource. With the change in emphasis, where we treat this now as a national resource, this is the change in our thinking which has come. Now, development comes ahead of regulation. Development is important. Regulating it is an integral part of development.
So therefore,
So development is a larger, if one may say so, the larger field, which means you regulate how it is processed, how it is progressed. Sometimes it is necessary not to allow removal in order to make sure that you get the maximum possible benefit of the mineral resource without compromising other factors. One of things which we never did, your question is very important. Things which we never did, we do today. And it started with environment law. It's now come into this law. You have to do what is called a cost benefit analysis. What is the cost of the activity? So today we look at life very differently. What is the cost benefit analysis of mineral development? You're taking the mineral out. It's value addition. So if you're taking coal out, the value of coal in generating electricity, and that electricity used to, say, manufacture aluminium, used to manufacture steel, etc., etc. So that's the value chain. That's the benefit. What's the cost? The cost is degradation of land, degradation of forests, human displacement. All this comes in the cost. And it's only when the benefits outstrip the cost. Now that is the new mantra of development. So now when we talk of mineral development, we talk of it very differently, from very different lenses. Then we thought in the days of the crown where development basically meant running away with whatever you could lay your hands on.
so only the limitation is with regard to mineral development.
But it's only mineral development is pretty much everything.
Correct, but then before imposing a tax, then the state has to see whether there is any limitation imposed by parliament by law on mineral development,
Correct.
which is traceable to
54.
50, no, and section 18 particularly of the act.
Of course.
It
18
gives
no, not-
various
sorry,
aspects.
Not only 18, the entirety of the act.
Correct.
I'm going to make that good. The entirety, there are so many other provisions in the act. 18 is a part of a larger, the entry 50 is not to be so narrowly construed. It's going to be much, because they are legislative entries. Your lordships have always held legislative entries have to be construed broadly. Today it's 18, tomorrow it may be something more, something less. The ambit of the entries has to be seen as the entries play with each other and how they interface. What I propose to do after I give the trilogy of cases, explain the one or two other cases, then I propose to address the court on an area which in one sense is untraversed so far. A rigorous analysis of entry 50 and how it plays out with entry 23 and entry 54. But ultimately, the answer to the question which this court is dealing with today in this reference will depend on 50 and the limits of 50. I've shown rule 8.
Should I address it?
And then there is a whole detail of how bidding process has to be done. And then the mining lease is to be granted. Important to show that today it is by statute that in order to obtain mineral rights, another aspect of this will be the state taxing rights created under a union legislation. So that will have some bearing. It's one thing where a private lessee creates, a private owner creates rights, but where a state itself has created rights as a facet of mineral development, can you tax those rights? Is going to be one aspect of entry.
When the center is created.
Yes, under a central legislation. The state may be acting under the central law, but when the center is creating these rights. That's what the court will have to see. To what extent, if 23, as the trilogy of cases says, is virtually gone, it's now all entry 54. Then the creation of these rights, where do you find these rights? Do I find them in 54? Do I find them in the state? Do I find them in the sovereign ownership of the state, or do I find them in law? But that will become an important element in the analysis of entry 50. That's why I'm showing all these provisions. Now, my lord, with this, may I? Yes, one last thing, my lord, the national mineral policy, then we are done with this. It's a 2019 policy. Page 2319. 2319. I just wanted to show para 3. The core of the functions of state in mining, and this is under the heading of mineral development, only to show that the word mineral development has a much wider sweep. The core of the state in mining will be facilitation and regulation of exploration.
Where do we read, Mr. Sarin? 232?
I'm sorry, my lord, 232. My mistake. Yes. So, this is only to show that mineral development includes regulation. That's all, even in the policy. And I'm so sorry. And just one thing, Manoj, and then I'm done with this. Responding to my lady's observation, please see section 13 of the Act. I've shown this earlier. Now, this comes under the heading of regulation. And in the regulation head, we have 13 to F. I had already shown this, 13 to F and 13 to I, which includes fixing and collection of fees, rent, security, royalty, and the payment to district fund, payment to this fund, payment to that fund. So regulation and development are overlapping concepts. In fact, development is the larger concept which it takes in regulation.
That is only with regard to.
Now, my lord, may I now, my lord, move quickly ahead? My lord, this policy is there, your lordships will see it. Yes. The trilogy, my lord. 61 to SCR 537 is Hinge Rampo. And this is in all these three judgments, my lord, to be can be found in volume 5. It begins at page 142 of volume 5. First paragraph gives the details. There were 2 leases. And my lord, para 2 is interesting. This will be a part of our submissions, especially when we deal with entry 49. Pursuant to section 5 of the Orissa Estates Abolition Act, all the right, title and interest of the Zamindar of Rampo in the lands demised to the first petitioner under the second lease vested in respondent 1, the state of Orissa. In fact, state by state, this is how the state became the owner of the minerals. Since the first petitioner has duly paid the rent reserved by the lease to the appropriate authorities and observed performed all the covenants. And interestingly, all these abolition acts, when they were challenged, they were upheld not under entry 23. They were all upheld under the power of acquisition of the state. And my lord, the details are given about the rules where a cess was imposed. And page 144, para 6, your lordship will find the challenge. The petitioners contain impugned acts and rules are ultra vires the powers of the legislature and any event repugnant to the provisions of the existing law. According to the petition, the cess levied under the impugned act is not a fee, but in reality a levy in the nature of duty of excise on the coal produced at the first petitioner's Rampol colliery and belongs so on. So alternatively, it is urged. In fact, but the first contention is relevant because this is what led to Justice Vanchu's dissent, which has created some confusion in India Cement. So the first contention was the excise duty. Second was alternatively it is urged that even if the levy imposes a fee relatable to entry 23 and 66 of the 7th schedule, it would nevertheless be ultra-vires having regard to the provisions of 54 and list 1 read with the Central Act 53 of 1948. This contention, Your Lordship may mark me. This is really what we are concerned with. The petitioner further alleged even if the levy is a fee, it would be similarly ultra-vires having regard to entry 52 and list 1, etc. Now, my lord, the discussion as far as the present case is concerned, what is relevant is from para 16 only to show what the act is. At page 149. Let us now examine the scheme of the impugned act. As the preamble shows, it has been passed because it was thought expedient to constitute mining areas and a mining areas development fund in the state of Orissa. It has 11 sections. Section 3 provides for the constitution of a mining area wherever it appears necessary for the state, it's necessary and expedient to provide for amenities like communication, water supply, electricity for the better development of the area in the state of Orissa, wherein any mine is situated, or to provide for so on. And these are not the general mining area provisions. Para 17 at page 150. The scheme of the act thus clearly shows it's been passed for development of mining areas in the state. The basis for the operation is the constitution of a mining area, and it is in regard to mining areas thus constituted that the provisions of the act come into place. It is not difficult to appreciate the intention of the state legislature evidenced by this act. Orissa is an underdeveloped state in the union, though it has a lot of mineral wealth of great potential value. Unfortunately, its mineral wealth is located generally in areas sparsely populated with bad communications. Inevitably, the exploitation of the minerals is handicapped by lack of communication and the difficulty experienced in keeping labor force sufficiently healthy. Mineral development therefore requires provision should be made for improving communications by constructing good roads. Now, this is important because the development itself requires regulation of activities and preservation. The discussion first part relates to whether it's a duty of excise. That begins at para 20. It's only necessary because otherwise the justice wants to dissent and mineral rights doesn't become clear. Para 20 notes the contention. It is, however, urged that the cess levied by 4.2 is in substance and reality a duty of excise. As we have already noticed, 4.2 provides that the rate of levy shall not exceed 5% of the valuation of the mineral at pit's mouth. In other words, it's the value of the minerals produced, which is the basis for calculating the cess payable by mine owners. And that precisely is the nature in which the duty of excise is levied. The entry empowers Parliament to impose duties of excise inter alia on goods manufactured when minerals are produced, etc., etc. When the minerals are produced from mines and excise is intended to be imposed on them, it would normally be imposed at pit's mouth, and that is precisely what the Impugned Act purports to do. It's also contended that the rate under 4.2 indicates it must operate not merely as a fee but a duty of excise. That was the contention. The argument will be carefully examined before the character of the cess is determined. It is not disputed that under entry 23 in list 2 with entry 66, the legislature can levy a fee in respect of mines and mineral development. Entry 23 reads thus, then when the entry is set out. We will deal with the condition imposed by the latter part of this entry later. For the present, it is enough to state that the regulation of mines and mineral development is within the competence of the state legislature. 66 provides that fees in respect to the matters in the said list can be imposed by the state, subject, of course, to the exception of fees taken by the court. The argument is, though the legislature is competent to levy a fee of mines and mineral, if the statute passed in substance and effect imposes a duty of excise that is traveling outside the jurisdiction and is trespassing on the legislative powers of Parliament. The argument is based on two considerations. The first relates to the form in which the levy is imposed, and the second relates to the extent of the levy authorized. The extent would always depend on the nature of services intended to be rendered and the financial obligations. If the services intended to be rendered to the notified mineral heirs require that a fairly large cess should be collected, and the correlation can be definitely established between the proposed services and the impost, it would be unreasonable to suggest that because the rate of the levy is high, it is not a fee but a duty of excise. In the present case, if the development of mining areas involves considerable expenditure, which necessitates the levy of the prescribed rate, it only means that the services being rendered to the mining areas are very valuable and the ratepayer in substance is compensating the state for services rendered by him. It is significant petitioners do not seriously suggest that the services intended are a cloak and not genuine, or that the taxes have no relation to the services, or they are unreasonable and excessive. Therefore, in our opinion, the rate the extent of the rate allowed to be imposed by 4.2 cannot by itself alter the character of the levy from a fee into that of a duty of excise. If the correlation between the levy and services was not genuine or real, or if the levy was disproportionately higher than the requirement of the services intended to be rendered, it would have been another matter. Then, as to the form in which the impost is levied, difficult to appreciate how the method adopted by the legislature in recovering the impost can alter its character. The character of the levy must be determined in the light of the test we have referred. The method in which the fee is recovered is a matter of convenience, and it by itself cannot fix upon the levy the character of the duty of excise. It has often been considered in the past, it's always been held, that the method in which it is levied may be relevant in determining the character, its significance and offense cannot be exaggerated. Then, Malad, all these classic cases are cited and propose to read these, Malad. This Ralaram, Malad, is, and then Bairamji Jijiboy. Then, Malad, in the next para is the Governor General Council, Province of Madras. I will, Malad, deal with them when I deal with Bombay Tire, which, and those cases, and RR Engineering. So, Malad, if I don't want to take up time here reading these cases. 24 onwards is the discussion where it goes into this entry 54 and entry 23. And this is important because, Malad, here they upheld it only on one ground. They said the declaration has to be post 1950. The 48 Act declaration doesn't deal you. Otherwise, they said it's a complete sweep. Please see para 24 onwards. The next question which arises is, even if the cess is a fee, and as such may be relatable to 23 and 66, is validity is still open to challenge because the legislative competence of the state legislature under entry 23 is subject to the provisions of list 1 with respect to regulation and development under the control of union. And that takes us to entry 54 in list 1. This entry reads thus. Then, Malad, the entry is set out. The effect, reading the two entries together, is clear. The jurisdiction of the state legislature under entry 23 is subject to the limitation imposed by the latter part of the entry. If Parliament, by its law, has declared that the regulation and development of mines should in public interest be under the control of the union, to the extent of such declaration, the jurisdiction of the state legislature is excluded. Please mark the words "to the extent of the declaration." In other words, if a central act has been passed which contains a declaration by Parliament as required by entry 54, and if the declaration covers the field occupied by the impugned act, the impugned act would be ultra vires, not because of any repugnance between the two statutes, but because the state legislature had no jurisdiction to pass the law. The limitation imposed by latter part of entry 23 is a limitation on the legislative competence of the state itself. This position is not in dispute. This is extremely important, this principle. So it's not a do-don't kind of repugnance that I must show a section in the Union Act which stops or which runs counter to a provision in the State Act for the State Act to fail.
In this paragraph, they don't discuss entry 50.
Because they were not concerned with 50. It was because they held it's a fee.
It's a fee.
The fee means 23. And here they said but for the fact that the declaration under 48 Act is not good enough, we have to struck the fees down.
So till 1957 Act came, they could do it.
Till the
States had the freedom.
And that's why in the next two cases, Tulak in this, it was struck down. But this principle was, everybody reaches back to Hinker and said principle was settled in that case. See, the next para also is relevant. It is urged by Mr. Amin that the field covered by the Impugned Act has already been covered by the MMRD Act 1948, and he contends that in view of the declaration made by under Section 2 of the Impugned Act, in the declaration of the 2 of the Impugned Act is ultra vires. Just 1 minute, this thing has gone away. 155, yes. The Central Act was passed to provide for the regulation of mines and oil fields for the development. It may be stated at this stage that Act 67 of 57, which has been subsequently passed by Parliament, Act 53 of 48 has now been limited only to oil fields. We are, however, concerned with the operation of the Act in 52, and at that time applied to mines as well as oil fields. Section 2 of the Act contains the declaration to the expediency and control by the central government. It reads thus, then the declaration is set out. It is common ground that at the relevant time, this Act applied to coal mines. Section 4 of the Act provides that no mining lease shall be granted after the commencement of this Act, otherwise done in accordance with the rules made under the Act. Section 5 empowers the central government to make rules by notification regulating the grant of mining leases or for prohibiting the grant of such leases in respect of any mineral or any area. Section 4 and 5 thus purport to prescribe necessary conditions in accordance with which mining leases have to be executed. This part of this Act has no relevance to our present purpose. Section 6 of the Act, however, empowers the central government to make rules by notification in the official gazette for the conservation and development of minerals. 6.2 lays down several matters in respect of which rules can be framed by the central government. This power is, however, without prejudice to the generality of the powers conferred on the government by 6.1. Amongst the matters by 6.2 is the levy and collection of royalties, fees or taxes in respect of minerals mined, quarried, excavated or collected. It is true that no rules have in fact been framed by the central government in regard to the levy and collection of any fees. But in our opinion, that would not make any difference. If it is held that the Act contains the declaration referred to entry 23, there would be no difficulty in holding that the declaration covers the field of conservation and development of minerals, and the said field is indistinguishable from the field covered by the Impugned Act. What entry 23 provides is that the legislative competence of the state legislature is subject to the provisions of List 1 with respect to the regulation and development under the control of the Union. And entry 54 on List 1 requires a declaration by Parliament by law that the regulation and development of mines should be under the control of the Union in public interest. Therefore, if a central act has been passed for the purpose of providing for conservation and development of minerals, and if it contains the requisite declaration, it would not be competent for the state legislature to pass an act in respect of the subject matter covered by the declaration. So it's not a section by section measure. The field is occupied and it is displaced from the state's list. In order that the declaration should be effective, it is not necessary that the rule should be made or enforced. All that is required is a declaration by Parliament that it is expedient in the public interest to take the regulation and development of mines under the control of the Union. In such a case, the test must be whether the legislative declaration covers the field or not. Judged by this test, there can be no doubt that the field covered by the Impugned Act is covered by the Central Act of 1948. I may just pause here for a minute, but this is very important for the building block of my submissions. The 48 Act, and that's why I trouble your lordship seeing it in some detail, unlike the 57 Act, had no provisions beyond saying the center may make rules, the state may make rules. That's all that it did. The center may make rules for the following, the state may make rules for the following. And the argument was, but there are no rules. And this court said, doesn't matter, all we need to look at the declaration. If the declaration is there, 23 then stands denuded.
But it is only to the extent.
That is not what the law is.
No, but.
Correct, but that's not how it is construed. And I'll come to that. It is not section by section. If the subject matter is occupied.
To the extent. That is what entry.
If I may just digress. In fact, the interpretation placed. Extent is not by the number of sections or the points covered. Yes. And the declaration has been understood very widely because the declaration now is the regulation and development of minerals. And that's how this court has always understood the declaration to be. Not by an individual rule or by a subsection or by a section.
Then what is the meaning to be given to the expression to the extent to which such declaration is made by Parliament by law to be expedient with the public interest?
Parliament could have made a lesser declaration. But the section 2 declaration says it is hereby declared that the development and regulation of mines is in the interest, public interest in the union. Finished.
Entire.
Gone.
So you're saying the entire development and entire regulation. Regulation is a part of development.
Correct. In other words, the entry said we will leave it to Parliament to define the extent. What this judgment is based is on the declaration. If your ladyship turns back for a second, the declaration is set out.
Yes.
At page 155. The last few lines of 155. It is hereby declared that it is expedient in the public interest that the central government should take under its control the regulation and development of mines and oil fields and the development of the minerals to the extent hereinafter provided. And all the rules for granting lease, this, that, everything goes.
But it's the section 2 says to the extent hereinafter
And
provided.
Correct. And there was nothing there, there's nothing left because that's why I showed all the sections. Right from the time of considering, notifying minerals, grant of leases, imposition of royalties, checking, safeguards, search, this form, you will do it in this form, the form will say like this is the lease you will execute, nothing is left.
There could be something beyond that. Beyond what is.
Nobody has
Expressly
anything.
detailed.
And the development of mineral areas.
Mr. Salve, actually, they were construing the relationship between entry 54 of list 1 and entry 23 of list 2.
That's right.
The reference to declaration is contained in
23.
entry 54. Entry 54
Entry
of list
54,
1.
yes, sorry, yes.
Once that declaration is made, because entry 54 is conditional, regulation and development, regulation of mines and mineral development, to the extent to which such regulation or development under the control of the union is declared by Parliament by law to be expedient. So
Correct.
declaration comes under entry 54.
Entry 54.
That declaration is contained in 2. Once the declaration is made under entry 54,
23 is out.
then 23 is out. So really speaking, they were considering the relationship between entry 23 and entry 54. It had nothing to do as such with the tag, because here was a fee.
Well, how this impacts, this does impact.
Come up at all.
Or this does impact. When I come to my analysis of 50, I will, because 50 also is subject to law relating to mineral development. For the present, I'm only,
Limitations by law.
I agree, accept that, completely accept it. But if Lordship don't, I'll come to 50 in a moment. For the present, I wanted to clear one ground. This is not a section by section analysis. Your Lordship's question to me was very important.
Extent provided hereinafter.
What is the meaning of to the extent provided? That has been interpreted.
23 by itself is made subordinate to a declaration. to entry 54 of
That's-
list 1. So because it says subject to the provisions of list 1, subject to the provisions of list 1 with
Yes.
respect to regulation and development under the control of the union.
Yes.
So the entirety of entry 23 is subordinate to entry
Subordinated.
54,
That's right.
to entry 54 of list
It is not quantitative.
Right. Once a declaration is made, then the test, as Justice Gandakarkar says, is the subject of the state act.
Subject.
Does it cover a field covered by the declaration?
That's
Now,
the point
but-
which I was
but-
trying to.
But that subordination is not there insofar as entry 50 is.
No, it's
concerned.
not. In fact, I'm sorry.
Entry 50 is, it's restricted by the limitations which are imposed.
Malad, I'm sorry. As I said in the morning, Malad, my submission is based not on the principle of subordination, because 50 is a very different mantra from 54.
Right.
I was first at the building block of my submissions. One of the questions which arose, and my learned friend said is, and Mr. Dwivedi repeatedly emphasized the word to the extent, to the extent. That's not how it was understood. It is the subject matter test which applies.
But in what context?
No, in 50,
The
54.
subject matter test squarely because entry 23 is subordinate to entry 54. Once a declaration is made in a law which is enacted with reference to entry 54, then the state law cannot occupy the same field.
That's the first step of my submission.
Right.
And
That has absolutely no bearing on the taxing provision. The taxing
whether it
legislation.
does or does not,
That's right. Because entry 50 is completely, while crafting entry 50 of list 2, they could have said subject to the provisions of list 1.
no, it
relating
could have
to
been much narrower.
Regulation and development.
On the contrary, it would have been narrower. My submission is going to be the words of limitation today are wider than the earlier. Because, my lord, the two concepts are very different. In fact, what my lord the Chief Justice is saying is exactly the point which I'm relying on. This is 50 has a very different construct. First, my lord, I want to fix where do the mineral rights source from today? And for that, because what is the tax on mineral rights? You have to first
In
get.
fact, entry 50 itself militates against the doctrine of occupied field because it says subject to limitations imposed by law by parliament.
Yes.
So when it says limitations imposed by law, it necessarily means that the law must engraft certain limitations
Right.
which will operate as a restraint on the taxing power.
I'm not completely in with.
Not by inference and not by
No,
the
no, no,
doctrine
no,
of
no.
occupied
No.
field.
Malad, I'm sorry. I'm on the contrary. As I said, Malad, there are 3 or 4 kinds. There are some which are shared. There are some which are occupied. 50 stands in a class by itself. I have not found any other entry like 50. What are the contours of 50? I'm going to come to, but Malad, to get to 50. One of the points made, and I was getting past those because there are 3 judgments on this. And this has a direct bearing on entry 4950, which is one of the important points of Kesaram I have to deal with. I was only not putting across the point that it is a subject matter test which applies to 54 with 22.
Right. 23 and 54 because of the relationship between the two entries, actually.
That's all that I wanted to show, Marat.
Yes.
And that discussion is very important because how that impacts 50. I continue?
Yes.
Yes. Responding to your ladyship's question, the expression to the extent hereinafter provided has been understood as a concept of subject matter, not of specific provisions of the Act. And if I may just show that again, that's the discussion made, which I was just reading at page 155. In the middle of para 24, the jurisdiction of the legislature under entry 23 is subject to the limitation imposed if Parliament by its law has declared that the regulation and development of mines should be in public interest, should be in the control of the Union to the extent such declaration, to the extent of such declaration,
Yes.
the jurisdiction of the state legislature is excluded to the extent of the declaration, not the specific provisions. Now the declaration is unconditional.
But in this paragraph 24, there is no reference to the extent hereinafter.
It is to the extent of the declaration.
They were dealing with not the 1957 Act. They were dealing with the 1948 Act.
Yes, but the language is the same. Exactly the same language. In fact, it is set out. The declaration is quoted. No, I just read it. It's there in the judgment. Para 25, please see para 25 again. If I read it a little slowly, the discussion will become clear.
About 7 lines from the bottom.
Yes.
Yes.
It is hereby declared that it is in the expedient and in the public interest that the central government should take under its control the regulation of mines and oil fields and the development of minerals to the extent hereinafter provided. Exactly the same declaration. It is common ground. It is common ground that at the relevant time, this act applied to coal mines. So you have to see in that context. Section 4 provides that no mining lease shall be granted after the commencement in accordance with the rules. And Section 5 empowers the government to make the rules by notification for regulating the grant of mineral leases or for prohibiting the grant, etc. Section 4 and 5 thus purport to prescribe necessary condition in accordance with which mining leases have to be executed. This part of the Act has no relevance for our present purpose. Section 6, however, empowers the government to, by rules, by notification in the Gazette for the conservation and development of minerals. 6.2 lays down several matters in respect of which rules can be framed. This power is, however, without prejudice to the generality of the powers conferred on the central government under 6.1. Amongst the matters covered by 6.2 is the levy and collection of royalties, fees, taxes in respect of minerals mined, quarried, excavated, and collected. It is true that no rules have in fact been framed by the government in regard to the levy and collection, but in our opinion, that would make no difference. If it is held that the Act contains the declaration referred to in entry 23, there would be no difficulty in holding that the declaration covers the field of conservation and development of minerals. So the cover is of the field, legislative field. And the said field is indistinguishable from the field covered by the impugned Act. And I submit that position, in fact, stands strengthened rather than weakened by the 57 Act. 57 is much wider than the 48 Act. So in that way, the extent is dealt with. That broadly, the grant of, right from birth to death,
Yes.
the grant of lease, license, fees, how you apply, what you do, how you run a lease, and the absolute power to frame rules, including the state government is given power by a union. So the field is occupied. And once that field is occupied, the declaration denotes entry 23. I'm not saying it denotes 50. I'm saying it denotes 23. Then para 26, it says, still remains to be considered whether 2 of the Act amounts to a declaration as required by Article 54. When the Act was passed in 48, legislative powers of the central and provincial legislatures were governed by the relevant entries in the 7th schedule. Entry 36 in list 1 corresponds to entry 54 in list 1. It reads thus, and then that entry is set out. It would be noticed that the declaration required by entry 36 is a declaration by dominion law. Referring to section 2, it is clear that the declaration contained in this section is put in a passive voice, but in the context there would be no difficulty in holding that the declaration by necessary implication has been made by dominion law. It's a declaration contained in a section passed by dominion legislature, and it is obvious a declaration by dominion law. When a declaration by dominion law be constitutionally a declaration by parliament under entry 54, and this was said it is not. That reasoning is not relevant for us today. So the court says that declaration under dominion legislation doesn't help. Para 36 at page 161. There's one more point which is yet to be considered. Mr. Amin contends that entry 23 in list 2 is subject to the provisions in list 1 with respect to the regulation and development under the controls of union. And according to him, entry 52 in list 1 is one such provision. In this connection, he relies on the entry which deals with industries, the control of which by the union is declared by parliament to be expedient in public interest. This act has been passed to provide for development and regulation of certain industries, one of which is undoubtedly a coal mining industry. Section 2 of the act declares it is expedient in the public interest that the union should take under the control industries specified in the first schedule. This declaration is the declaration made by parliament, and if the provisions are to be read with the declaration covered by the same field is covered by the impugned act, it would undoubtedly affect the virus of the act. But in dealing with the question, it's important to bear in mind the doctrine of pith and substance. You've already noticed that in pith and substance, the impugned act is concerned with the development of mining areas notified under it. The Central Act, on the other hand, deals more directly with the control of all industries in the course of industry of coal. I'm so sorry about that. This discussion is a little important because entry 23, there is also an eclipse by 52. Could be. One is directly 54 versus 23. Now, the interplay of 52 and 23, this is the only judgment we deal with. And it says if the subject matter is the same, of course, even that declaration would affect 23. But then they say by pith and substance, this is from development of mining areas that deals with industry, and therefore the two don't overlap. On that basis, this act is upheld. The majority, now this comes closer home, page 162. PC para 37. Our conclusion is that the impugned act is relatable to entries 23 and 66 of list 2 of the 7th schedule. Validity is not impaired and affected by 52 and 54 of list 1, read with Act 65 and 53. In view of this conclusion, it is unnecessary to consider whether the impugned act can be justified under entry 50 of list 2. Whether it is relatable to 24 of list 3 and suffers from the vice of repugnancy. The result is petition fails. So this judgment primarily went on the basis, it's a fee, there is no declaration in the 48 Act which denotes, therefore sustains. It notices 52 could have overshadowed, but it says the subject matter of 52 is different.
So they didn't deal with entry 50 list 2 as such.
They did. Justice Vanchu deals with it. And Justice Vanchu's dissent is considered in India Cement and criticized. And that sentence criticizing his reasoning, it doesn't say so and so. When I read India Cements, I'll explain, is considered to be a mistake. That how could India Cement say in one place royalty is not a tax, one place royalty is a tax? Vanchu J starts at page 162. At page 163, para 42, he tees up the first issue about tax and fee. I won't trouble your lordship reading that discussion. His lordship says, in principle, there's no difference between tax and fee. And then at page 166, para 46, let me then look at the pith and substance of the cess which has been imposed. The cess consists of a levy not exceeding 5% of the value of mineral of the pit's mouth. Prima facie, such a levy is nothing more or nothing less than a duty of excise. Entry 84 of list 1 gives power to levy duties. And then he sets out entry 84, then the famous Governor General and Council in province of Madras. And I don't need to trouble the court with the line of reasoning he follows. He comes to the conclusion at page 171, para 52. He starts analyzing the law, and the last 3 lines of para 52, looking at that, at page 172, the lordship says, I don't want to read the whole para because we're not really concerned with the reasoning. Looking at that, the cess in this case is in pith and substance nothing other than a duty of excise under entry 84, and therefore legislature was incompetent to levy it as a fee. So, what turned with him was that this was a tax on production or manufacture because it was on the mineral removed. Then he gets into, because of the view he took, then he had to consider the alternative submission of entry 50. And that discussion is on para 53.
Right.
The next contention on behalf of state of Orissa is the cess is not justified as a fee. It's a tax under item 50 of list 2 of the 7th schedule. 50 provides for taxes on mineral rights, subject to any limitations imposed by Parliament by law relating to mineral development. This raises the question as to what are taxes on mineral rights. Obviously, a tax on mineral rights must be different from taxes on goods produced in the nature of duties of excise. If the tax on mineral rights also includes tax on minerals produced, there would be no difference between taxes on mineral rights and duties of excise. Now, pausing here for a minute, a royalty which is based on the quantity of mineral produced, then by this definition should be duty of excise. I'm not saying this is the correct definition, possibly it's wrong, because this confuses, this is missing the distinction between measure and subject matter. But his first part of his logic was that it must be different from a duty of excise. The difference can be understood if one sees that before minerals are extracted and become liable to duties of excise, somebody has got to work the mines. The usual method of working them is for the owner of the mine to grant mining lease to those who have got the capital to work the mines. There should be no difficulty in holding that taxes on mineral rights are the taxes on, please mark the words, the right to extract minerals, and not the taxes on the minerals actually extracted. Thus, taxes on mineral rights would be confined, for example, to taxes on leases of mineral rights, and on the premium or royalty for that, taxes on such premium and royalty would be a tax on mineral rights, whereas taxes on minerals actually extracted would be duty of excise. Now, the fallacy in this is whether royalty itself is on extracted mineral. I mean, this whole line of reasoning with respect is wrong. with respect to Justice Vanchu, and it is a minority. What India Cement said is, and with respect correctly says, that if a tax on extracted mineral is excise duty, then a tax on royalty can't be a tax on mineral. Because royalty itself is on extracted mineral. It is not on the right to extract a mineral. That is what India Cement said in this context.
Basis for levying royalty is on the mineral extracted.
Exactly. Now, if that, according to Justice Vanchu's logic, is an excise duty, then royalty itself is an excise duty. Now, where are we getting with this? So, it is not, his first part of his reasoning is clearly minority, and with all respect to him, it is wrong. It's against the run of authority, before and after.
Should we go to the next authority now in the trilogy?
Yes. This is the only bit, and he's the only judge who has dealt with entry 50 ever. Next is Malat Talak, 64 4 SCR 461, and in this very bundle, your lordship will find it at 278.
64 for SCR.
461. Not all these SCRs are being put in soft form now.
And they are absolutely up to date.
Oh, I see.
And we now have not only the ESCR, which is in the PDF form, but DGSCR, which is like a book. So you can have the joy of actually flipping the pages as well with the DGSCR.
78, yes.
So really speaking, we have to go back to practice of citing SCRs.
But in
now.
this court, we never cited anything other than SCRs. Till
SCRs
the SCRs went off.
SCR was way behind schedule, almost 4 years behind schedule, but now it's absolutely up to date. And
By
we have
end
now
80s, it went off the rails.
DGSCRs.
And we always found it makes much softer reading, the old SCRs.
Yes.
Broad print.
The print was much bigger and
They don't have parallel.
Head notes were being approved by the honorable judges. So head notes are more
authentic.
Farmer.
that was the reason why this. That's what the kind of situation we came in India Cement with regard to the so-called error, printing error, etc. All this would not have happened if someone who had taken the trouble to looking at the parchment.
But it didn't have paranumbers, it was a big problem.
No, there was no parallel.
And we also have neutral citations now.
At that time, yes.
We used it forever.
We
but I
should be
don't
now
think there was
using
ever-
neutral citations at all, because all of us should be using neutral citation, because now it's across the spectrum. Whatever journal you're citing, there's one neutral citation for all judgments from 1950.
Please get it for. And I'm sorry, I'm a little out of date on this.
You know, as in the US reports, you have
Yes.
349 US
Yes,
22.
but always
So
cross-reference.
we have now neutral citation for every judgment of the Supreme Court from 1950.
Malad, this Angar J,
What page is it?
Malad, page 272. No, sorry, 278, my mistake. Now, this is Malad, a follow-up. The same Orissa Act, upheld by the court, was struck down by the High Court post 58. And that your lordship get at para 4. Shall now proceed to set out briefly the grounds on which the learned judges of the High Court allowed the petition of the respondents. Stated shortly, the contention which the learned judges of the High Court accepted was the Orissa Act has been rendered ineffective or suppressed, should be superseded by central enactment, the Mines and Minerals Act 57. Orissa Act had been enacted by virtue of 23 of List 1, which reads thus: the legislative entry under which the latter Central Act was enacted was 54, which ran thus. The Central Act carried in its second section a declaration envisaged by the last words of the entry. Based on these facts, the argument to which the learned judges acceded was that on coming into force of the Central Act, the Orissa Act ceased to be operative by reason of the withdrawal of the legislative competence by force of the entry of the state list being subject to parliamentary declaration and the law enacted by Parliament. They had that for this reason, the Orissa Act should be deemed to be non-existent as and from June 1st, 1958, and for every purpose with the consequence, there was lack of power to enforce and realize demands for the payment of fee at the time when the demands were issued. It's the correctness of the judgment challenge before us. Before proceeding further, it is necessary to specify briefly the legislative power on the relevant topic, for it is on the precise wording of entries in 7th schedule of the Constitution and scope and effect of the state and central legislation, which we have referred to. Article then 246(1) is set out. Then 246(3) is set out. And just below that, it's coming now to the 7th schedule. Entry 13 of the state list vests in the state legislature the power to enact laws on the subject of regulation in mines and mineral development. This should be 23 development, subject to the provisions of List 1 with respect to regulation and development under the control of the Union. It would be seen that the subject to the provisions of List 1, the power of the state to enact legislation on the topics of mines and minerals development is plenary. The provision in List 1 is, as is already noticed in entry 54 of the Union list. It may be mentioned that this scheme of the distribution of legislative power between the center and the states is not new, but merely a continuation of the state of affairs, which prevailed under the CJI Act 1935, which included a provision on the lines of entry 54 of the Union list, which then bore the number 36 of the Federal list, and an entry corresponding to entry 23 of the state list, which bore the same number in the provincial legislative list. There is no controversy that the Central Act has been enacted by Parliament in exercise of the legislative power contained in entry 54, or as regards Central Act containing the declaration of what is required by entry 54 for it enacts in section 2, and then the declaration is set out. It does not need much argument to realize that to the extent to which the Union government has taken under its control the regulation and development of minerals, so much was withdrawn from the ambit of the power of the state legislature under entry 23, and the legislature of the state, which had rested on the existence of the power under the entry, would to the extent of the control be superseded or rendered ineffective. For here we have not a mere case, not of mere repugnancy between the provisions of the two enactments, but of a denudation or deprivation of states' legislative power by the declaration which Parliament is empowered to make and has made. It would be, however, apparent that the states would lose legislative competence only to the extent to which the regulation and development under the control of the Union has been declared by Parliament to be expedient in public interest. The crucial inquiry, therefore, has to be to ascertain this extent, for beyond it, the legislative of the power of the state remains unimpaired. As the legislation by the state in this case before earlier one in point of time, it would be logical to first analyze the State Act and determine its purpose, width, and scope, and the area of the operation, and to consider what extent the Central Act cuts into it or trenches into it. The object of the Orissa Act, as disclosed by its preamble of the constitution of mining areas and the creation of a mining area development fund in the state. Section 3 empowers the state to constitute and alter the limit of the mining areas. The object of these mining areas was inter alia the provision of amenities like communications, water supply, electricity, and the better development of areas where any mine was situated, as well as to provide for the welfare of residents or the workers. 4 is the provision empowering the state to levy a cess or fee for all extracted minerals from any mines in any mining area, with a limit, however, that the rate should not exceed 5% of the value of the minerals. And then that section 5 is set out. Para 8 onwards is at page 281, foot of the page. We shall now turn to the Central Act. The long title of the Act specifies that the twin purposes are the regulation of mines and the, just one minute, and the, yes, and the development of minerals. both under the control of the union. Section 2 we have already extracted. 3 contains definition of the terms and may be omitted. 4 to 10 form a group under general restrictions on undertaking, prospecting and mining, and relate to the rules and regulations under which prospecting license and mining leases might be granted, the period for which they may be granted or renewed, the royalties and fees that would be payable. The next group consists of 10 to 12, which deals with procedure for obtaining prospecting licenses or mining leases. 13 to 17 are grouped under the caption which reads rules for regulating the grant of prospecting license. 13, which starts empowering the government by notification to make rules for regulating the grant, etc. And then all these sections are done. Then comes section 18, which is the provision for other objects of the Act, the development of minerals. It will be necessary to set out some details, then 18 is set out. Para 9. The question for consideration is whether the extent of control and regulation by the Central Act takes within its fold the area subject to the EUROSA Act. Counsel for the appellant raised 4 points that the object of the Act. May I come straight to the discussion? The discussion starts from para 12, page 286.
Yes.
Before referring to the judgment dealing on this aspect, it would be convenient to refer to the Central Act of 48, on the basis of which the constitutional validity of the EUROSA Act was impugned. Then that act is set out. Mr. Justice Gajendra Garkar's judgment is set out, which I've just read, I don't need to read it from here. Yes.
After the quotation.
Page 288, immediately after extracting it. It's only necessary to add to the validity of the impost to the firm. However, for the reason whereas the EUROSA Act was a post-constitution enactment and the Central Act of 41 was a pre-constitution law in terms of entry 54, Parliament had not made the requisite declaration, but only the previously existing central legislature, it was held not within the meaning of 54 and the state enactment continued to be operative. Since the Central Act 67 contains the requisite declaration by Union Parliament under entry 54, and that act covers the same field as the Act of 48 in regard to the mines and minerals, we consider the decision of the court concludes the matter, unless there were any material differences between the scope and ambit of 54 of the Act 48 and that of 47. The learned counsel was not able to point out any matter of substance in which there is difference between the two enactments. It was suggested whereas section C empowered for rules to be made and taxes, there was no specific power. It is not necessary to discuss the materiality of the point because what we are concerned with is the power to levy a fee. And there is an express provision in section 13. Apart from the implication of 25, it says, any rent, royalty, fee, tax or sum due to the government under the terms of the prospecting license, under the certificate, etc. may be recovered. We ought to add, so section 25 was referred to, that's very important. We ought to add that besides we see considerable force in Mr. Setalvat's submission, that 1 and 2 of 18 are wider in scope and amplitude and confer larger powers on central government than the corresponding provisions of the Act of 48. The second point urged by the appellant is based on that section 18 of the Central Act merely lays a duty. God, which page is it? Keeps jumping off. The second point urged by the appellant is based on the fact that section 18 of the Act merely lays a duty on the central government to take steps for ensuring the conservation and development of the mineral resources. The submission is that even assuming under the powers conferred there are in conjunction with 13 of the Act, it would be competent for the central government to frame rules in the line of the EUROSA Act for the development of mining areas and for that purpose to provide for the imposition of fees and for the constitution of a fund. Still, no such rules have been framed, and until the rules were made, Central Act would not cover the field, and that the EUROSA Act would continue to operate. In support of this submission, reliance was placed on the on the decision of this court in Tikaramji and state of UP. That's the sugarcane case. Para 14. We consider the submission in relation to the Act before us without force, besides being based on a misapprehension of the true legal position. In the first place, the point is concluded in the earlier decision, in Hinger Rampo, where this court said that in order that the declaration is effective, it is not necessary that the rule should be made or enforced. All this is necessary is a declaration by Parliament that it was expedient in the public interest to take the regulation of development of mines under the control. In such a case, the test must not be whether the legislative declaration covers the field or not. But even if the matter was res integra, the argument cannot be accepted. Repugnancy arises when two enactments, both within the competence of the two legislatures, collide, and when the Constitution expressly or by necessary implication provides that the enactment of one legislature has superiority over the other. Then, to the extent of repugnancy, one supersedes the other. But two enactments may be repugnant to each other, even though the obedience to each of them is possible without disobeying the other. The test of two legislations containing contradicting provisions is not, however, the only criterion of repugnancy. For if a competent legislature with a superior efficacy expressly or impliedly evinces its intention, with an intention to cover the whole field, the enactments of the other legislature, whether passed before or after, would be overborne on the ground of repugnance. Where such is the position, the inconsistency is demonstrated not by a detailed comparison of the provisions of two statutes, but by the mere existence of two pieces of legislation. Hearing having regard to the terms of 18(1), it appears to us that the intention of the Parliament was to cover the entire field, and thus to leave no scope for the argument that until rules of flame, there was no inconsistency and no supersession of the State Act. So they said 18 covers everything. Your Lordship may only mark, and I'll develop this tomorrow when I'm dealing with entry 50, that it is expressly or by necessary implication. It was next urged that the scheme of the legislative entries under the Constitution as previously under the Government of India Act, the power to levy fee with an independent head of legislative power under each of the legislative fields and not merely incidental power flow from the grant of power of the subject matter. It was sought to be established even if the Union could levy a fee under the Central Act. It would not effect or invalidate a state legislation imposing a fee for a similar service. This argument again proceeds on a fallacy. It is no doubt true that technically speaking, the power to levy a fee under the entries in the three lists is treated as the subject matter of an independent grant of legislative power. Whether it is incidental power related to a legislative head or an independent legislative power, it is beyond dispute that in order that a fee may validly be imposed, the subject matter of the main head of legislation, in connection with which the fee is imposed, is in the legislative power. The material words are fees in respect of any of the matters in this list. It is therefore a prerequisite for the valid imposition of fee that it is a matter in respect of the list. If by reason of the declaration of Parliament, the entire subject matter of conservation of development of minerals has been taken over for being dealt with Parliament, thus depriving the state of power to which it is possessed, it follows that the matter in the state list, to the extent of the declaration, is subtracted from the scope of entry 23. Therefore, there would, after the Central Act, be no matter in the list to which the fee could be related in order to render it valid. Now, this is a very important piece of reasoning. It empties out the list, as it were. And this is perhaps why Kannadasan said, if entry 50 is denoted, it shifts to entry 97. So it's not that 23 is still available, just that parliamentary legislation prevails.
So it's eclipsed.
It's gone. It's to borrow the words of the court, it is subtracted from the scope and ambit of entry 20.
Even then we again
One more paragraph, my lord. Although it is in the context of Section 6 of the General Clauses Act, there's a further discussion in para 19, page 292.
Yes.
Para 19, my lord, at page 292. Before proceeding further, it will be convenient to clear the ground by adverting to two matters. One, the effect of a central act under its exclusive legislative power, which covers the field of an earlier state act, which was competent and valid when enacted, is not open to doubt. The parliamentary enactment supersedes the state law and thus virtually effects a repeal. That's how the Lords looked at it. And then applied the Section 6 principle. And thirdly, the last in the trilogy is Bajnath Kedia, 69-3 SCC 838. It's at page 412 of bundle 4. Bundle 5, sir. 412 of bundle 5. Volume 5, sir. At page 414, the second paragraph of the judgment, one Jyoti Prakash Pandey, obtained on March 23rd from Babu Bijan Kumar Pandey and Shrimati Anila Devi, acting on our behalf, etc., etc., registered leases to quarry stone, ballast boulders, and chips from blocks so and so. The leases were to commence, and that is to say, they were for a so and so period. Para 2 is important. On passing of the Bihar Land Reforms Act 1950, the ex-landlord ceased to have any interest from the date of the vesting. In their place, the state of Bihar became the lessor, and under Section 10 under the Land Reforms Act. The section of Section 10 were given below. After the vesting of the estate of the intermediaries, the state of Bihar as the next lessor recognized the lease for quarrying stone on the remaining period, and the Deputy Commissioner Santhal Paraganas asked for the rent, etc., etc. So that's how the land reform laws worked. The contention is to be found. The demand was raised just above paragraph 3 at page 416. The contention is that the amendment of Section 10 to the Bihar Land Reforms Act is ultra vires the Constitution, and 22 does not legally entitle the recovery of dead rent royalty in the schedules of the Bihar minor mineral concession rules. To understand fully the argument on behalf of the appellants, a resume of the legislation on the subject of mines and minerals is necessary, and the government, then the Government of India Act, entry 35, etc. You ought to have seen all this. And the federal word, the change, para 4 gives the 1948 Act. Your lordships have seen that already. Para 5 at page 418 says the leases of the appellant's predecessors were granted in 55. During the subsistence of the Act of 48 and the rules of 49, it is also to be noticed that a fresh declaration was made by Parliament as required by entry 54 list 1 union list of the 7th schedule. The existing laws, however, continued without a declaration by Parliament. The field of legislation might have been open to the state legislatures under entry 23 of list 2 state list of the Constitution, but no law was made except what was enacted by the Bihar in the Land Reforms Act about vesting of mines in the state and the exertions of the state of the lessor in place of the lessors. Then, my lord, para 7, your lordship start dealing with the 57 Act. The whole discussion continues. Section 16 is noted, section 17 is noted, section 18 is noted, and para 10 at page 421, it may be pointed out here that the rules made under section 13 do not apply to minor minerals in view of the provisions of section 14. The state of Bihar has not made any rules under the Bihar minor mineral concession rules. The modification of the terms of the existing mining leases were provided for in section 16, but that provision applied to mining leases granted before October 49. The provision of mining leases modification of terms did not apply to minor minerals because the definition of existing mining lease excluded a lease of minor mineral. The power to modify leases in the case had to be found elsewhere. The argument of the appellant is that apart from the provision of the second proviso to section 10 added to the Land Reforms Act in 64 by Act 4 and the second rule added by Rule 20 of the Bihar minor mineral concession rules, there was no power to modify the terms. The provisions of law are said to be outside the competence of the state legislature and the Bihar government. With regard to the state legislature, it is contended that the scheme of the relevant entries in the union and the state list is that to the extent to which the regulation of mine and minerals development is declared by Parliament to be expedient, the subject of legislation is withdrawn from the jurisdiction of the state legislature. And therefore, Act 67 leaves no legislative field to the Bihar legislature to enact Act 4 of 55, amending the Land Reform Act. Now, the discussion begins.
Para 13.
Para 13.
About 5
Third
lines
line.
from-
Therefore, it is necessary to address ourselves to the first argument that the legislative competence to enact the amendment after the Act 67, we have to consider the position in relation to it. Entry 54 of the Union List speaks both of regulation of mines and minerals, development, and entry 23 subject to entry 54. It is open to Parliament to declare it is expedient in the public interest that the control should rest in the central government. To what extent the declaration goes for Parliament to determine, and this was the commensurate with public interest. Once the declaration is made and the extent laid down, the subject of the legislation to the extent laid down becomes an exclusive subject for legislation by Parliament. Any legislation by the state after the declaration entrenching upon the field disclosed in the declaration must necessarily be unconstitutional, because the field is abstracted from the legislative competence of the state legislature. The proposition is also self-evident that no attempt was made rightly to contradict it. There are also two decisions of the court in Hingir, Rampur and Talak in which the matter is discussed. The only dispute, therefore, can be to what extent the declaration leaves scope for any legislation by the state legislature. If the impugned legislation falls in the ambit of such scope, it will be valid. If outside, it must be declared invalid. The declaration is contained in section 2 of Act 67 of 57 and speaks of taking under control of the central government the regulation of mines and the development of minerals to the extent provided in the Act. We have thus not to look outside Act 67 or 57 to determine what is left within the competence of the state, but have to work it from the terms of that Act. In this connection, we may notice what was decided in the two of the cases. In Hingir Rampur's case, then not Hingir Rampur is discussed, Talak is discussed, Para 16, your lordship may see. These two cases bind us and apply here. Since the Bihar state legislature amended the Land Reforms Act after coming into the force of Act 67 of 57, the declaration to the latter act would carve out a field to the extent provided in the Act, and to the extent entry 23 would stand out down. To sustain the amendment, the state must show the matter is not covered by the Central Act. The other side must, of course, show that the matter is already covered and there is no room. We have already analyzed Section 67. The Act takes over the regulation of mines and development of minerals to the Union, of course, to the extent provided. It deals with minor minerals separately from other minerals. In respect of minor minerals, it provides in 14 that Section 413 of the Act do not apply to prospecting licenses and minerals. It goes on to state in section 15 that the state government may by notification in the official gazette make rules for regulating the grant of prospecting license and mining leases in respect of mineral and for the purposes connected. And that until the rules made by the government regulating grant of prospecting license and mining leases of minor mineral, which immediately in force, would continue. It is admitted that no such rules are made by the state. It follows that the subject of the legislation is covered in respect of minor minerals by the express words of 15. That's very important. So although the rules are to be made by the state, it is under the union legislation. Parliament has undertaken and laid down that the regulation and grant of prospecting licenses and mining leases of minor minerals, and for that purpose must be by rules made by the state government. Whether the rules are made or not, the topic is covered by parliamentary legislation, and to that extent the powers of the state legislature are wanting. Therefore, there is no room for state legislation. So, this answers at least one point, that where it said the statement due to that extent 23 is preserved. That's not correct. Where the state is acting as a delegate of parliament, it is still 23 gets denuded. And para 18 is also very important. Shri Lalnarayan Sinha argued that the topic of legislation concerns land and therefore falls under entry 18 of the state list. And he drew attention to provisions on the subject of mines in the Land Reforms Act as originally passed. The abolition of the rights of intermediaries in mines and vesting of these rights in the lessors of the state government was a topic connected with land and land tenures. But after the mining leases stood between the state government and the lessees, any attempt to regulate those mining leases will not fall in entry 18 but in entry 23. Even though the regulation incidentally touches land, the pith and substance of the amendment of section 10 of the Reforms Act falls in entry 23, although it incidentally touches land and not vice versa. Therefore, the amendment was subject to the overriding power of Parliament declared in section 67 of the Act of 57 in section 15. Entry 18 of the state list is of no help. Mr. Lalnarayan Sinha next contended that the provision of section 414 do not envisage control of the union, which is a condition precedent to the ousting jurisdiction of entry 23. Obviously, Mr. Lalnarayan Sinha reads union as equivalent to union government. This is erroneous. Union consists of three limbs, namely Parliament, Union Government, and Union Judiciary. Here, the control is being exercised by Parliament, the legislative organ of the Union, and that is also controlled by the Union. By giving the power to the state government to make rules, the control of the Union is not negatived. In fact, it establishes that the Union is exercising control. In view of the two rulings of the court referred to earlier, we must hold that by enacting 15 of Act 67 of 57, the Union has taken all the power to itself and authorized the state government to make rules for regulation of leases. By the declaration and enactment of Section 15, the whole of the field relating to minor minerals came within the jurisdiction of Parliament, and no scope was left for the enactment of the second proviso. The enactment of the proviso was without jurisdiction. Just leave for consideration the second sub-rule added. It will be noted that the rule as stood previously applied prospectively and came into full after the regulation of the rules. The second sub-rule made applicable to those provisions to all leases subsisting on the date.
See, you have described your argument as the building block towards section 50,
Entry.
but tempting as they may be, these arguments don't have any connection with entry 50.
They do.
So
Very
should
good.
I say that
They do.
these are all cheese argument, whereas we are looking at staring at
No,
chalk
they do.
argument?
They do. I have to get there. But I have to first start because there were 2 or 3 basic points which I need to get past. What is the extent of parliamentary legislation? What is the nature of parliamentary legislation? What is the run of the entries? What is the interaction between the entries? And my lord, because 54 and 23 are directly connected, 54 and 50 are directly connected. And how 54 operates is a very important element of my argument that when one considers what are limitations, what is the approach brought to bear in interpreting entry 54 and the Act of 57.
But if you come to a case which deals directly with 50, you will be, at least my concern, you will be able to assuage my concern
Yes.
on whether, where we are heading with the arguments that you are advancing.
All right, let me tell you, Lordships, except the High Courts and India Cement and Kesoram, nobody has dealt with 50 squarely. I mean, let's be clear, nobody has. I'm going to be showing, my lord, the Patna High Court, the Mysore High Court, in my favor, the Punjab and the Rajasthan High Court against it. But, my lord, ultimately the High Court judgment, 9 of your lordships are considering it. My interpretation of entry 50, of what is the true meaning of limitations imposed by law by Parliament, I have to clear the ground. And one of the important aspects my learned friend said is, look, so much is left to the state. Or mine and minerals are left to the state. That's not right.
Actually, Mr. Sarve, when we are operating squarely within the field of entry 23 of list 2, vis-a-vis entry 54 of list 1, once there is a declaration made by law enacted by Parliament, which is referable to entry 54 of list 1, the entirety of the field gets abstracted or subtracted, as the judgment said, from the field of the state legislature. And therefore, Parliament alone is then the exclusive legislating body on that subject, which forms the subject matter of the declaration.
Yes.
We are here in a situation where that principle would apply to tax on mineral rights. Now, even if there's a declaration under the central law, the MMDR Act, notwithstanding that declaration, Parliament cannot take upon itself the power to impose a tax on mineral rights because that doesn't fall within the scope of legislative competence of Parliament. The only then question is this, that's a distinction between these cases. The only question which then survives is whether the declaration by Parliament completely denudes the authority of the state legislature to legislate in the area of, on the area of mineral rights, because any such legislation would impede the field of regulation and development.
I do not put it on that ground.
Unless you say that, look,
in fact,
taxation per se is barred because it will impede completely.
No, my lord, I'm sorry. I put it on a very different basis. There are 3 or 4 building blocks now to entry 50. And since, my lord,
Well, one thing we are very clear now is that Parliament does not govern the legislative domain of taxation on mineral rights. This is not assigned to Parliament at all. Now, does a legislation by the state get affected merely because of the fact that there is a declaration by Parliament under entry 54 of list 2?
I'm not relying on the declaration. I don't rely on the declaration. That's why I said, my lord,
but if you're not relying on the declaration, all these cases, the 3 cases which deal with entry 54 and 23 really have no relevance.
But for the field is not exceptional.
Yeah, that's not. My lord, these cases are relevant for the purpose.
The broad concept.
Yeah, exactly.
But they don't answer the question
No, my lord,
for us.
but this is the, if I may say so, this is the canvas in which this question has to be now addressed. May I tell my lord, may I formulate my point and then develop? I now come to entry 50 squarely.
How do you formulate it? Let's,
Yes.
so that, we got
The
about
entry, it's there in my written submission, but let me, my lord, formulate it only. My case is that entry 50 is sua generis. It's a kind itself. The 7th schedule does not follow a fixed pattern of distribution of fees. there are different ways in which legislative fields are distributed. And each kind has its own nuance. It might be helpful if I give, in fact, I'm going to give a skeleton tomorrow morning in writing, but broadly, this is what it is. And for interpreting entry 50, skeleton submission. Well, your lordship will have to see the different ways in which these powers are distributed between the union and state. In order to give content and meaning to the expression, subject to any limitations imposed by Parliament by law relating to mineral development.
Give content and meaning to the expression.
Limitations imposed by Parliament by law relating to mineral development. Your lordships will also have to examine the subject matter of the tax. Taxes on mineral rights. And it is on an analysis of these two elements of entry 50 that your lordship will have to consider the validity of a state law imposing a tax on royalty. Where these cases would be of assistance to the court is in understanding in the constitutional concept or in its constitutional sense the nature of the Act of 1957, not just the declaration. So, my lord, let me be clear what my lord the Chief Justice was pleased to put to me, my lord. Declaration is not the basis of limiting 50. Unless I am able to make good the 52nd Act, the 57 Act in its different avatars, starting from 57 and as amending over and over again, considered fiscal implications of state exactions as a essential element of development of mineral rights. And by Section 9, exhaustively define what a state could exact for mineral rights.
Just kindly repeat this submission, sir. Section 9 exhaustively
Exhaustively defines
defines.
what a state can exact
Okay,
for mineral rights,
correct.
to the exclusion of any other kind of exactions. I would not be able to bring it within the limitations. I mean, I put my point negatively. That's what I have to show.
The exclusion of
Any other kind of.
any other.
Contingent demand.
In course of your submission, you spoke about, those precious metals, gold and this thing, and you said it was the edict of the Raja. Can we have a bit of research done whether Rani also had something to do with that?
Raja, you must be holding, my lord, in trust
My Lord,
for and on behalf.
Mr. Parasaran used to always tell us this. He says the most misunderstood notion is the male-female. He says we forget that the woman is the Ardhangini.
Yes.
And when you say the man, it's only half of the whole.
So Rani would have a role.
My Lord, in today's world, my Lord, it's lucky if the Raja gets some say. The Rani occupies the field. To the exclusion of the Raja.
Chief. Human.
Actually.